right, friends, welcome back to Justice Matters One-on-One. I am here with my friend and former colleague, a 35-year federal prosecutor, Kevin Flynn. Kevin and I worked together at the D.C. U.S. Attorney's Office. I did 30 years as a prosecutor. He did 35. I'm not great with math, but I'm going to calculate that adds up to 65 years of prosecutorial experience. And what Kevin and I are going to do is we're going to jump on here regularly, and we're going to talk about what we are seeing in the Trump administration on the legal front. You know, what Todd Blanche is up to, what Pam Bondi is up to, what the Trump administration is up to, particularly when it comes to criminal cases. So I have an ask of you all. You know, I know you watch these Justice Matters videos, and I greatly appreciate that. We're trying to come up with a name for a recurring segment where two career prosecutors just give you the real deal about what's going on. For example, in the grand jury, what's going on in court, what's going on when Todd Blanche sits down and interviews a convicted felon like Ghislaine Maxwell. What's really going on from the perspective of two guys who lived that life for decades in the grand jury, in trials, debriefing convicted felons to see if they were going to become cooperating witnesses, to see if they were willing to tell the truth about the crimes of others. And I could use your help. We need a name. We need a name for this new series, and I know you're more creative than me. I'm going to go out on a limb and say you may even be more creative than Kevin. So send your thoughts to my website, glennkirschner.com. Send me a message. Give me your ideas about what we should call what I hope will be a recurring segment. So, Kevin, thank you for joining me. Thank you for your career of service as a federal prosecutor. I think you and I were both largely violent crime and homicide prosecutors, but we handled lots of other cases along the way. And so what I want to start with is I want to talk about the reporting that broke in recent days about how Jeanine Pirro, the United States Attorney for the District of Columbia, our former professional home, and U.S. Attorney Pirro, of course, is formerly a Fox News host, how she has sent prosecutors into court in two cases trying to get the grand jury to vote out felony assault charges on two individuals who got into it a little bit with the police in Washington, D.C., and the grand jury in those two cases said no. A total of 4 times they said no. And not to bury the lead, these two people have now been charged with misdemeanors, which are not required to be run through the grand jury. So let me ask you first, Kevin. You spent a heck of a lot of time in grand juries in Washington, D.C. Can you just take our viewers through what the normal practice is when you're presenting a case to the grand jury and asking them to vote out a felony charge?
Sure. Well, the one thing, first, you have to keep in mind that even before you go into a grand jury, you've made decisions as a prosecutor about whether or not the case is actually worthy of going to a grand jury. In other words, whether or not you can ultimately prove the case beyond a reasonable doubt to a trial jury. The standard for a grand jury is probable cause. In other words, probable cause that a crime was committed and that the defendant probably was responsible for it. That is a lower standard than beyond a reasonable doubt. And so when you go into a grand jury, which by the way is 20 to 23 citizens who sit in six-week to 2-month terms, depending on local versus federal, they are the voice of the community, and you have already decided whether or not that case should go before the grand jury to begin with. And so you and I have heard for years, and members of the public I'm sure are familiar with the saying that a grand jury would indict a ham sandwich. And it's always bothered me in the sense that it makes it sound as if prosecutors take every case that comes to them and then run them through a grand jury for indictment on serious felony charges. By definition, a felony is a crime that brings with it more than a year in jail potential penalty. And so what it says to me, and to get to the point about what just came out, is that prosecutors in that office, starting at the top, are not exercising discretion on cases that for political reasons are being pushed as felonies. And grand juries are standing up for the community. They are the voice of the community. They're standing up for the community. They're the voice of reason here, and they're saying no. And so I'll ask you, how many times in the course of your career, Glenn, do you think that a grand jury no-billed one of your cases?
Yeah, so let me count them up. That would be zero, zero, because we don't present bullshit cases to the grand jury. We only present cases, as you well know, where we have a good faith belief that, first of all, we can meet the evidentiary hurdle of probable cause to believe a crime was committed and the defendant committed it. But we have to have our eye on the trial ball when we're doing that, because we know we're going to have to prove the case beyond a reasonable doubt at trial, significantly higher burden than probable cause. So, maybe if we have bare probable cause, but we don't think we'll ever be able to build beyond that, you know what we do, Kevin? We don't present it to the grand jury. We might bring it as a misdemeanor charge if we think we can prove a misdemeanor, a much lower level crime. But misdemeanors don't have to be run through the grand jury, only when you're seeking a felony charge. How many no bills, and it's called a no bill when the grand jury tells a prosecutor, no, we vote not to indict this case. How many no bills did you have?
I actually had one.
Oh, well, it's been nice having you here today, Kevin.
But it was,
Tell us about that briefly.
sure, it was a case that it was two guys got into a fight in the hallway of in the stairwell of an apartment house, and one guy got the better of the other guy, and then got him down on the ground, and then hit him 2 or 3 more times, and ended up causing his death. I knew when I went in that was going to be a tough case, because grand juries. First, there was a mutual combat issue there. In other words, they both the decedent had consented to getting into this fight, and in fact, I believe, as I remember the testimony, it was back in 1989, I think. As I remember the testimony, a witness said that the decedent was getting the better of the defendant, and the defendant rallied and ended up being able to get the decedent on the ground, and the grand jury no-billed. It was a very close vote, as I remember, but they. It was a situation that I argued for. I argued for indictment, and it was a case that I couldn't myself decline to put before the grand jury. I thought it was the case that needed to have the community through the grand jury express their opinion about it, and they did. But if I had it to do over again, I think I would do the same thing, and I'm confident a grand jury would probably do the same thing too, with the same evidence and the same proof.
And it's such an important point that it's kind of an open question when we as prosecutors think, we think we can satisfy our burden before the grand jury, but you use the term the conscience of the community. The grand jury sits as the conscience of the community. They're the ones who have to decide, and I'm so glad that they are in that position, because they get to act as a check or a guardrail or a bulwark against prosecutorial overreach, abuse, or misconduct. And we're going to get there in a minute with what Jeanine Pirro had her prosecutors do. But they sit as the conscience of the community, and sometimes we put the evidence before them, and we obviously live with their determination. If they say, you know what, this is a close case, but we don't think you have it, Kevin or Glenn, and they decline to indict, they no-bill the case, we generally live with that. Occasionally, if we come upon new evidence, we have a new witness, we can represent it to the grand jury with the approval of usually the U.S. attorney, sometimes higher over at the Department of Justice, proper Main Justice, but rarely do we do that. So between the two of us, Kevin, 65 years of prosecutorial experience, one no bill, one time the grand jury declined to indict. We had a big office, something like 325 prosecutors with lots of turnover, and so I can't remember any other no bills, quite frankly. I'm sure there may have been some along the way, but it is so extraordinarily unusual because we act as the guardrail in the first instance in not putting weak or insufficient cases before the grand jury, such that they don't have a reason to vote no to no bill. But now let's turn to the two grand jury cases where both times they told Jeanine Pirro, No, we are not indicting felony assault. One case is the somewhat famous case now because we've seen a video of it played on an endless loop. It is the young man who threw a Subway sandwich at a police officer. There was no injury to the police officer. You see it bouncing off the officer's chest and bulletproof vest. And that person also happened to be a paralegal at the Department of Justice who was protesting against Donald Trump introducing fascism or trying to into the streets of the District of Columbia. And he appeared to lose his cool. He threw the sandwich at the officer. And Jeanine Pirro sent her prosecutors in to try to indict a felony assault, which carries a felony assault on a federal officer, which carries up to 8 years in prison for throwing a sandwich. And the grand jury rejected that charge. They said no. And then Jeanine Pirro had her people go on to bring a misdemeanor charge, which does not only carry significantly less potential confinement, it will probably result in a sentence of probation in the event this young man is convicted of a misdemeanor assault on the police officer for throwing a sandwich at him. What's your main takeaway from the fact that under those facts as I related them, Jeanine Pirro decided to send prosecutors into the grand jury to try to secure a felony 8-year in prison indictment?
My takeaway is that it was a political prosecution, and that this was, if this had been another type of defendant and another type of victim, that charge, I doubt that, I severely doubt that charge, it may not have even been papered in the first case, because as your viewers may or may not know, there's a process that's called intake, where the police make arrests, and the very next day, or even the same day as the arrest is made, the case goes to a prosecutor's intake office, and it's decided then, even before you get to the point of maintaining or considering whether or not to go into the grand jury, those cases end up getting either severely reduced down to misdemeanors or no papered altogether. So that's the first thing that I'm keeping in mind here. The second thing is I find this extremely ironic, and I think ironic is a euphemism, and I could use other words like disturbing, distressing. That case where a protester threw a sandwich at a police officer was charged, our old office attempted to charge that as a felony when we're talking about hundreds of protesters who caused serious injuries to police officers on January 6th, and those people got pardoned, and some of them are even finding, at least one of them, is finding employment at the Department of Justice right now in the office of Ed Martin, who was for a minute the interim U.S. attorney in D.C. and is now in charge of a quote-unquote weaponization office or unit over at DOJ. So you take the Subway sandwich on the one hand, we're going to go, the Justice Department is going to go balls to the wall on that case. Meanwhile, the same Justice Department is complicit with the White House in terms of handling with leniency and even with praise people who caused serious injuries to officers, and several of whom actually died as collateral consequences of that conduct on January 6th. One set of defendants is lionized and made heroes. Another defendant is put into a situation where he was facing felony charges. He and actually the second person that you're referring to as well, for extremely trivial conduct that caused no injury to the officers in question. These are political prosecutions.
And I'm so glad you brought up the similar circumstances where, I shouldn't call them similar circumstances, but where Donald Trump directed people to go to the Capitol, fight like hell or you won't have a country anymore, stop the certification of Joe Biden's election win, stop the steal, and they beat the hell out of police officers, Capitol police officers, Metropolitan Police Department, MPD officers, beat some of them damn near to death. Some ended up dying or taking their own lives shortly thereafter. And these people are pardoned for their conduct and celebrated by Donald Trump, and yet somebody who protests Donald Trump's attempt to militarize the streets of Washington, D.C. with absolutely no basis, no factual basis to do it, that person who loses his cool and tosses a sandwich is somehow public enemy number one. It just feels like extreme prosecutorial overreach at a minimum for Jeanine Pirro to have pursued felony charges against that person. And I'm so glad that the grand jury, sitting as the conscience of community, told her, hell no. Just for our audience, the name of the Subway sandwich wielder is Sean Dunn, who, as I mentioned, was a paralegal at the Department of Justice, who, of course, was instantly terminated, fired by Pam Bondi. We're going to move to a second incident where a woman named Sydney Laurie Reed was out there protesting the way the police were dealing with undocumented immigrants, and she put herself between some officers. I think it was an ICE officer and an FBI agent, and an immigrant, an undocumented immigrant, they were trying to take into custody. There was some pushing and some shoving. The FBI agent ended up getting some scratches on the back of their hand. There were no major injuries. There were no major punches thrown. There was some pushing and some shoving there. Well, they arrested Sydney Laurie Reed, and Jeanine Pirro sent her people into the grand jury again, seeking what? A felony assault charge on an officer, an 8-year offense. And this I find even more remarkable than the first instance. Three times, according to the public reporting, the grand jury refused to indict Miss Reed on a felony assault on a police officer. Kevin, what is your takeaway from the fact that somehow she presented a case 3 times to a grand jury and they said no all 3 times?
I think it's extraordinary that it got past one. The fact is that if a grand jury issues a no bill, and presumably you've put your best foot forward as a prosecutor the first time through, because you generally you don't put all of the witnesses that are available to you before the grand jury as a matter of practice. You're generally putting the witnesses that you want to lock into stories. You're putting the most important witnesses. In a case like this, you would probably have just put in the victim, quote unquote, themselves, victims, maybe possibly an eyewitness. But that case went into the grand jury as well as it could the first time through. And if you were basically the second time, it's hard for me to think that there was a lot of evidence that was put to the grand jury the second time or the third time. And so what that says to me is that this wasn't a prosecutor trying to have the grand jury reach a decision. It was a prosecutor trying to browbeat the grand jury into contorting justice and reaching a result that was consistent with the politics of the prosecutor and not consistent with the ends of justice.
And let me add a twist to that, because somebody made a comment somewhere in response to a previous discussion I had on this issue. And they said, maybe the prosecutors who Jeanine Pirro insisted go into the grand jury and present this case over and over and over again, maybe they knew that obtaining a felony indictment was the wrong thing to do. I have no idea if that's accurate or not. I do know there are great, honest, ethical people at the D.C. U.S. Attorney's Office still who I suspect are not really interested in doing the dirty bidding of Jeanine Pirro or Pam Bondi or Donald Trump. They have their ethical constraints, but, that is another possibility, I guess. I see a case being presented 3 times in factual circumstances that make plain it is at a minimum prosecutorial overreach. It begins to look like prosecutorial abuse of the grand jury process. Maybe more will creep out when these 2 cases go to trial, if they go to trial on the misdemeanor charges. Let's finish with this, Kevin. Because, listen, we are prosecutors through and through, right? Somebody once said, you shake me awake in the middle of the night and ask me, what are you? I say, prosecutor. I kind of still feel that way, even though I'm away from the practice for a few years. You are recently retired, but that is kind of in my core who I am and what I am. So let me ask you this question. How do you feel about the fact that each of these defendants, the Subway sandwich thrower and the woman who stepped between officers and somebody they were trying to detain, how do you feel about the fact that they've been charged with misdemeanor crimes and they will potentially be held accountable for their conduct?
I'm trying to think back. The best way for me to answer that is to imagine myself in intake, and an officer is sitting across from me, and they have made an arrest for APO in one instance where they had a
Assault on a
sand.
police officer.
I'm sorry, assault on a police officer. And in one instance, the officer has suffered a few scratches, and in the other instance, they've had a sander thrown at them. And I project myself back when I was in that duty, and I think the first words out of my mouth would have been, "Are you kidding me? Do you really even want us to go forward with this on a misdemeanor?" And to be honest with you, I mean, I don't want to be disparaging of the victims, the law enforcement victims in this case, although I guess I'm just about to be disparaging about them. You and I worked with hundreds and hundreds of really brave and honest and dedicated police officers. And all of those officers, hundreds if not thousands over the years, if I think back, I don't know of a single self-respecting officer that would insist on those facts for charges to be brought in the first place. Technically, I'm sure that in those instances, the officers would have said that in the intake process, look, we felt like we had to make a lockup. I had PC, but how many times were you in intake and you had officers come in and say, listen, there was PC here. We needed to make an arrest. The situation was getting out of hand, but just don't even think about going forward with this. All right, that was just
All the time.
all the time, and so it's even from jump. This was something that I am absolutely, even though I don't know it with 100% proof positive, I am sure that a call was made from the top by Pirro herself at intake. This has to come in. This case has to be papered. It has to be papered as a felony, and after that, I'm sure that there were repeated communications because that's the way offices work, and that's the way, we both worked significant cases that the U.S. attorney at the time was interested in, and we would get calls or we would have meetings with the U.S. attorney. Never once, and I came in, it's a matter of record, I'm a registered Democrat, but I came in under the Ronald Reagan administration. I served under, I believe, 7 presidents, as I think more Republicans than Democrats. Not once over those 35 years with all the cases that I handled did I ever get any direction from the U.S. attorney or any supervisor that smacked of politics. And I feel sorry for the people who are, I feel bad for the prosecutors who put those cases in front of the grand jury. Let's assume for a moment that they were doing what they thought they had to do. They were following orders. In the first place, I think if I had gotten orders like that, I would probably have found a way to decline and possibly would have faced professional consequences. I wouldn't be surprised, I guess my bottom line is, if right now those prosecutors who didn't get who got no bill by the grand jury are themselves being scrutinized as to whether or not they failed to perform up to the quote-unquote standards of Jeanine Pirro.
Yeah. And let me kind of pick up where you left off on the charging decision. Practically speaking, these are probably cases that ordinarily wouldn't be charged. When we work protester cases, we would have massive numbers of people who would be arrested during the sort of heat of the moment of the protest, pushing and shoving and yelling and throwing. And most of those cases, we would decline to charge. They got no papered, is the term of art when we decide not to charge somebody who was arrested by the police in a protest setting. And as you say, usually the officers didn't even necessarily want those cases to be charged because they were just trying to calm everything down in the moment. But here's the flip side of the coin. Don't throw sandwiches at police officers. Don't throw anything at police officers. I understand this young man who was a paralegal at the Department of Justice was really angry and energized and animated and against fascism coming to our city, Washington, D.C. I am all those things as well. But if you throw something at a police officer and it makes contact, that's a form of assault called a battery and unconsented to touching. It's a violation of the law, and you may find yourself catching a misdemeanor charge. And it's supported by the evidence, by the facts. Whether we would exercise our prosecutorial discretion to charge it or not, it is a violation of the law. The same holds true with the woman who put herself between the officers and the person they were trying to detain. I understand why, and I would encourage everybody to stand up, to speak out, to stay strong, to march, to rally, to protest, to do all of that. But don't throw things at police officers. Don't get yourself in between. Film it, document it, but don't get yourself in between police and somebody they're trying to detain, because that violates the law, and you could easily catch a charge, even if only a misdemeanor charge. So I will say it seems like the facts support misdemeanor charges, not felony charges, but in these two instances. So listen, I'm thrilled to have you here, Kevin. We're going to do this, I hope, early and often, taking on the legal issue of the day in real time as best we can. And I will invite the viewers one more time. First of all, let me know how you enjoy this series with Kevin and I. And second, let me know if you can come up with a good name for two prosecutors with a total of 65 years of prosecutorial experience, highlighting what's really going on at the Department of Justice and in the courts and in the Trump administration on the legal front. So, Kev, thank you for being with me. We're going to do this again soon. And thank you to all of you for tuning in to Justice Matters.